In addition to the legal provisions we already discussed in the previous modules, there are also numerous and varied laws that relate directly to the responsibility or duty owed by emergency service agencies and their employees to the communities they serve. We will explore those laws within this, the final chapter of the textbook. Once completed with this module, you should be able to discuss the requirements for emergency responders to perform their duties safely and ethically, explain why emergency responders must meet credentialing or licensure requirements to function within their roles, describe how a community accesses its local emergency services, discuss the implications of emergency management for both responders and the communities they serve, identify and describe various fire prevention activities, and discuss the environmental impacts of emergency service activities on a community. As with our other modules, this chapter begins with a scenario, or more appropriately named, a case study, given that the unfortunate scenario was ripped directly from the headlines. Every so often, a news story will tell the tale of a person in desperate need of help. 911 is called, and the caller must wait the painstaking minutes it takes for help to arrive without receiving any direction by the dispatcher. On the other hand, there are also stories where 911 pre-arrival instructions are credited with saving a person's life. In this particular case, a child was entangled in some playground equipment and stopped breathing as a result. A bystander called 911 and waited for emergency personnel to arrive. No pre-arrival instructions were provided by the dispatcher to the caller. Unfortunately, the child died, and the 7 to 8 minute gap between when the caller found the child and CPR was finally initiated by the first arriving first responder is being blamed for the death. The news media is questioning why the dispatcher did not talk the caller through CPR like the dispatchers in a neighboring community would have done. This scenario may raise a few questions for you. Is there any legal requirement that a community provide a certain level of care as it relates to 911 dispatch? Is emergency medical dispatch required, or is it merely an option that communities can either decide to use or not? Is there liability for either having or not having 911 emergency medical dispatch? And if so, does that liability change if the dispatching agency is a governmental, a nonprofit, or a for-profit agency? In this particular case, the dispatching of emergency medical personnel is handled by the local sheriff's office, and the sheriff has stated that providing emergency medical dispatch actually exposes the agency to more liability than not providing the service. Do you think that is true? The sheriff also went on to state that the sheriff's office has frequent turnover of dispatchers, and the cost associated with providing training to new personnel on a regular basis is too great. Do you think cost should be a factor in such decisions? Legal liability and concerns aside, what do you think would be the right thing to do in this situation for the safety, health, and wellness of the community and its citizens? Are they better off without 911 pre-arrival instructions than if an emergency medical dispatching system was used? Keep this scenario in mind as we move through this module. Rest assured, we will be revisiting this topic later. To begin this chapter on the duty owed to the public by those who provide protective services, consider for a moment the type of person you think would embody the behaviors and traits of a firefighter or EMS provider. Is that person appropriately and adequately trained and educated within the appropriate discipline? If so, are they licensed or certified in that discipline? In all states, firefighters and EMS providers must receive a certain level of training and education to function in their respective roles. Many states require some type or combination of licensure and certification across those disciplines, firefighting and EMS. In areas served by volunteers in particular, however, such requirements may be seen as a burden to recruitment or retention. Licensure and certification of firefighters and EMS providers is something we will explore in a little bit. Before a firefighter or EMS provider can mitigate an emergency, he or she must first respond to the scene of that emergency. In doing so, that firefighter or EMS provider often increases the risk to both him or herself and the community by driving an emergency vehicle in a fashion that is less than safe or responsible. Driving with due regard, even when responding to an emergency, is an absolute must, regardless of whether lights and siren are activated. When picturing your ideal firefighter or EMS provider, is that person calm under pressure and also able to control his or her own emotions to remain cool and collected, which means driving responsibly to the scene of an emergency to minimize the risk to not only the public, but to him or herself and the emergency crew? That is something the law definitely considers important, and we'll discuss the legalities of emergency response within this module. Lastly, those emergency service workers and their employers must be good stewards within their communities who function with the highest level of integrity. What does that mean legally? We will explore that as well. While we have already touched on the importance of health, safety, wellness, and fitness for emergency service providers in previous modules, those subjects relate directly to the duty owed by emergency service employees to their communities. The jobs performed by firefighters and EMS providers are critical for the safety, health, well-being, and fabric of our society and communities. Sick providers can lack effectiveness and actually place a burden on the system that undermines its effectiveness. For this reason, many states actually have laws that disqualify individuals with certain ailments from being firefighters or emergency service workers. A person with chronic cardiac problems or a history of uncontrolled epilepsy, for instance, may not serve as a firefighter in some states without the consent of a physician. Other laws also recognize the need to control the spread of certain diseases and provide a means for emergency or medical workers to obtain information pertinent to blood-borne pathogens in the event of a significant exposure to another individual's blood or bodily fluids. We already discussed these laws in previous modules, so we will not delve any deeper here, besides recognizing that these laws all relate directly to the public's expectation that emergency service workers have a certain level of health and wellness that allows them to be effective without needlessly placing others at an unacceptable risk. As each state has the 10th Amendment right to legislate for the safety, health, and well-being of its populace, the requirements to be a firefighter or EMS provider in each state can vary considerably. Despite this variation, however, there are typically some common threads across the states. A formal training program in firefighting or EMS through an approved educational entity or training center is commonly required. After such training and education, the student may be required to pass some type of standardized examination before receiving a recognized credential, such as a license or certification, within that discipline. Once a particular credential is obtained, it may also be necessary to obtain continuing education or professional development on a regular or periodic basis to maintain that credential, depending on the state. As far as EMS credentialing is concerned, there is a nationwide effort spearheaded by the National Highway Transportation Safety Administration to alleviate disparities between the states and standardize EMS across the country. The 4 levels of EMS recognized within the National EMS Educational Standards include Emergency Medical Responder, Emergency Medical Technician, Advanced Emergency Medical Technician, and Paramedic. The National Registry of Emergency Medical Technicians is a nationwide credentialing agency for EMS providers, and it has adopted the same 4 levels of credentialing as described by the National EMS Educational Standards. Despite this push for a nationwide standard, however, it is still well within the purview of the individual states to manage their EMS systems as they deem appropriate. Therefore, disparities in recognized levels, credentialing requirements, education, and other facets of EMS still exist between the states. The credentialing of individual providers is often just one step in providing EMS, as the EMS agencies within the state are often treated as standalone entities that must receive state approval to function as well. Therefore, these credentialing requirements can include not only individual EMS providers, but EMS agencies and services as well, depending on how the state law is written. As this textbook was written to serve as a general outline for legal principles that apply broadly across different agencies and states, being familiar with the EMS credentialing requirements within your particular state is very important. While many firefighters are often EMS providers, the 2 disciplines are indeed separate, and there are different organizations at the national level that define credentialing standards for both. We already talked about NHTSA and NREMT on the EMS side. With regard to firefighting, educational programs and certifications are often accredited by either the International Fire Service Accreditation Congress or the Pro Board Fire Service Professional Qualifications System. The United States Fire Administration's National Fire Academy also has a Fire and Emergency Services Higher Education Group that provides recognition for students who complete FESHI-approved courses at the associate, bachelor's, or master's level. Despite the differences between the fire and EMS disciplines, one thing is the same. Both can have very different credentialing requirements depending on the state in which that credential, a certification, or license is being sought. Many states also recognize other types of professional credentialing available to firefighters and EMS providers beyond their initial certification or licensure. Such additional credentials can include driver-operator, fire inspector, emergency services instructor, hazardous materials technician, community EMT, tactical EMS, critical care paramedic, and numerous others. As always, familiarity with the requirements within your particular state is critical. Once a firefighter or EMS provider obtains a certification or license, it is not uncommon for the state to require ongoing training or continuing education to renew that credential on a periodic basis. NREMT, for example, requires EMS providers holding a NREMT certification to renew that certification every 2 years. Again, such renewal typically requires some type of continuing education, formal refresher, or other professional development requirement to be eligible for recredentialing. It is not unusual for a provider to be required to pay a fee not only for original credentialing, but to renew that credentialing as well. With all that being said, there are also jurisdictions with credentials that do not have an expiration date. In those cases, there is no renewal process, but that does not automatically mean that a certain level of continuing education or professional development is not required of those credentialed providers. Sometimes there are other laws unrelated to professional credentialing that require certain types of ongoing or periodic training, education, or professional development. For those jurisdictions that require a certain credential to function as a firefighter or EMS provider, if that credential expires, that typically means the person can no longer function in the role or capacity for which that credentialing was required. Allow your EMS license to lapse, for example, and you can typically no longer provide EMS at anything beyond a layperson first aid level. Many jurisdictions may provide a process for reinstating a lapsed credential, but the steps involved are commonly more difficult than if the credential was simply renewed prior to its expiration. As already mentioned, given that each state has the ability to legislate within its own borders for the safety, health, and well-being of its populace, credentialing requirements for firefighters and EMS providers can vary significantly from state to state. For those who practice in a single state, these different requirements are no big deal. For those who work in a community or area that borders another state, however, the requirements of that other state may be very important, especially if the need arises to cross over state lines to provide mutual aid or other types of emergency services, because a credential in one state is not automatically valid in another. If you remember back to an earlier module, this may sound somewhat confusing, as the full faith and credit clause in the Constitution, Article 4, Section 1, requires states to respect the public acts, records, and judicial proceedings of other states. If you have learned anything by listening to these modules, however, it is that laws are often interpreted differently, and even with what seems to be a clear law, the answer as to how that law is applied in certain circumstances or situations typically depends on the facts presented. As far as the full faith and credit clause is concerned, the Supreme Court has ruled that the clause does not require a state to accept another state's laws if doing so would run afoul of that state's own laws or legitimate public policy, which also explains why some controversial topics like same-sex marriages, legalization of marijuana, and others still create significant legal challenges when a legal activity in one state is not legal in another. As a result, states are under no obligation to recognize professional credentials issued by other states. Given the proverbial shrinking of our world and the somewhat transitory nature of our populace, however, many states have developed procedures for reciprocity with other states. These systems provide avenues for individuals credentialed in one state to obtain a similar credential in another state. The challenge with such systems, though, is that they are just as varied as the laws related to initial credentialing in firefighting and EMS. Some states have compacts or agreements that provide for transferability of professional credentialing between those states. Some rely on national credentialing organizations like NREMT or IFSAC to serve as the foundation or basis for a system of license reciprocity. Other states require candidates to complete or challenge a state-recognized examination process. In other areas, it may not even be possible to obtain reciprocity, and the relocated firefighter or EMS provider may have to retake his or her initial education in the new state to obtain a professional credential. For as much as we think of the United States as being a single country, the autonomy provided to the individual states really underscores the regional differences and mutually exclusive philosophies that continue to exist across different areas. With this credentialing conundrum in mind, what happens when large-scale incidents occur and out-of-state responders are called in to assist? Think about the influx of emergency service workers into New Orleans after Hurricane Katrina or Houston after Hurricane Harvey. Luckily, these credentialing issues were addressed back in 1996 by the ratification by Congress and adoption by the states of the Emergency Management Assistance Compact. This agreement allows federal EMS and medical assets to function across state borders without any credentialing issues. Each state has a law in place that actually defines and outlines its participation in the EMAC. This agreement operates through several federal bodies under the National Disaster Medical System, which include the Disaster Medical Assistance Teams, Disaster Mortuary Operational Response Teams, International Medical Surgical Response Teams, and even National Veterinary Response Teams. These teams are designed to provide medical care and other auxiliary services at the scene of a disaster site for at least 72 hours without any external support. They also have significant personnel resources available. A DMAT, for example, consists of physicians, nurse practitioners, physician's assistants, nurses, pharmacists, pharmacy technicians, respiratory therapists, paramedics, and EMTs. You may have noticed the language earlier that mentioned the EMAC allows federal EMS and medical assets to work across state lines without credentialing issues. As these healthcare providers are credentialed within a given state and are not typically federal employees, how can they move across state borders to function in such a fashion? The answer is that once a DMAT or other team is activated, those professionals on the team are considered to be intermittent federal employees who are subsequently paid by the federal government while functioning at an incident. Therefore, while they may not be federal employees on a daily basis, the members of the team are federal employees at the time they are functioning with the team, which allows them to practice medicine across state lines under the terms of the EMAC. As some additional information, team members are protected from tort liability while functioning on one of these federal teams, and they are also covered by the Uniformed Services Employment and Reemployment Rights Act, which protects their full-time employment while they are away from their jobs on active duty with a DMAT. As a reminder, we discussed USERRA in a previous module. At this point, let's shift gears, no pun intended, from professional credentialing to another very important legal issue for firefighters and EMS providers, the laws that govern the operation of emergency vehicles. Each state has laws that define rules of the road. These laws govern things such as direction of travel, speed limits, stopping at stop signs, and so on, and apply to all vehicles traveling on roadways within the respective state. There are typically additional provisions in these laws that subsequently provide special rights and privileges to emergency vehicles. There are also laws that define what an emergency vehicle is in the first place. Traffic and emergency vehicle laws are all defined at the state level and, as a result, can vary quite a bit from state to state. Regardless of the state in which an emergency vehicle driver is operating, there is always a requirement that the operator drive with due regard. This means that the driver of the emergency vehicle must operate the vehicle reasonably given the circumstances. A failure to do so could result in civil or, in some cases, criminal liability. We talked about governmental and statutory immunity in an earlier module, and some courts have viewed emergency vehicle operations as a discretionary act which qualifies for such immunity, while other courts consider the operation of an emergency vehicle to be a ministerial act without the benefits of such immunity. Regardless, the duty to drive with due regard is ever present, as simply having lights and siren activated does not mean anything goes, so to speak. As far as the privileges provided to emergency vehicles are concerned, it is not uncommon for certain rules of the road to continue to apply to emergency vehicles regardless of whether or not they are responding to a call, transporting a patient, or performing some other vital function. One such example is that most states have laws that make it illegal for a motorist to leave the scene of an accident without stopping and waiting for law enforcement or exchanging information with the other motorist if property damage occurred. The recognized privileges provided at law to an emergency vehicle do not typically waive this requirement to stop at an accident scene, which means being involved in an accident means that emergency vehicle is considered out of service until the incident is resolved in accordance with the law that applies in that particular state. Another example would be stopping for a school bus that has its red lights flashing. Unless specifically allowed by the law in the state, emergency vehicles must commonly yield to a stopped school bus. Considering the risk involved, even if allowed to ignore a school bus's stop sign and signals, doing so and causing injury to a child would probably not be considered driving with due regard. Again, unless the law specifically grants an emergency vehicle the ability to do something, or not do something as the case may be, the emergency vehicle operator must follow the traffic laws that apply to all motorists, even if lights and siren are activated. From a practical standpoint, no one wants to be in a motor vehicle collision, firefighters and EMS providers in particular. Ambulances and fire trucks are expensive. They also have a lot of mass and can do a lot of damage. Emergency vehicles involved in accidents generate a lot of bad press for the fire department or EMS agency involved, and there can also be a great deal of potential liability for both the agency as well as the operator in the event of a collision. Aside from the laws that govern the operation of emergency vehicles, many states also have laws that stipulate the actions of other motorists when in the vicinity of an emergency vehicle. The most common require the motorist to yield by pulling to the right and waiting for the emergency vehicle to safely pass. As anyone who has driven an emergency vehicle can tell you, however, motorists often fail to follow these rules of the road when approached by an emergency vehicle. As an emergency vehicle operator, it is vital to expect the unexpected, function with a higher sense of awareness, drive defensively, and exercise due regard at all times. Even if not at fault for a collision, the fallout of such an incident can be overwhelmingly negative for the emergency vehicle operator, the occupants in the emergency vehicle, other motorists, and the fire department or EMS agency. Moving away from the rules of the road, let's take a look at ethics and related subjects. For those firefighters and EMS providers who are employed by governmental agencies, there may be state or even local ethics or conflicts of interest laws designed to govern potentially unscrupulous behavior. These laws or similar policies typically forbid employees from accepting gifts above a certain dollar amount or value, being involved in purchasing decisions in which the employee has a financial interest, or using privileged information obtained through his or her governmental employment for personal financial gain. Private employers may also have similar policies in place for their workforce as well. If governed by ethics or conflicts of interest laws, knowing the details of those provisions is important to ensure compliance and avoid potential civil or even criminal problems that may arise if those laws are broken. Related directly to providing EMS services is a recognition that medical practitioners must seek opportunities for professional development on an ongoing basis to remain current in the field. Additionally, EMS agencies and their providers must take the time to identify errors or potential errors in the medical care provided to a patient, learn from mistakes, reinforce positive experiences, and evaluate patient contacts with the benefit of time, hindsight, and other resources. Such activities are part of continuous quality improvement initiatives or programs and are a mainstay in medical disciplines, EMS included. These activities are so important that many states actually have laws in place that require EMS agencies and providers to have a CQI process and participate in related CQI activities. Essentially, society as a whole benefits when medical providers utilize hindsight, case reviews, and other CQI tools as a means to avoid potential future medical errors. While such medical errors are unfortunate, it is important for EMS providers to learn from them and not make them again. If a medical provider could be held responsible for errors in care that are discovered through a CQI process, however, it would arguably be in the provider's best interest, legally speaking, to not affirmatively try to identify such errors that may have occurred. To avoid this concern, state laws typically protect CQI efforts from use or discovery in legal proceedings. This means an EMS agency may take affirmative steps to identify potential or actual medical errors in care and implement plans to avoid them in the future within a safe environment or process. Rather than sticking one's head in the proverbial sand and hope no one ever finds a mistake that may have occurred, CQI and subsequent legal protections of the process help to ensure a medical error that occurs will be addressed by the involved medical provider or agency to ensure a similar error does not occur in the future. Familiarity with your specific state's laws regarding CQI activities for EMS agencies is important for any EMS manager or provider. As far as public access to the EMS system is concerned, it is easy to take for granted the availability of 911 systems to call for help. Believe it or not, however, it was not until the 1999 passing of the Wireless Communications and Public Safety Act that actually established 911 as a standardized number to call across the country for emergency services help. Given evolutions in technology over the years, the 911 system has evolved to incorporate landlines, cell phones, and voice-over IP networks, and some public safety access points are even now beginning to accept and process text messaging. If you remember back to the scenario at the beginning of this chapter, many states have mandated the use of pre-arrival instructions for dispatchers to give emergency medical advice to laypersons who call 911. In these emergency medical dispatch systems, commercial products are often utilized by dispatchers that follow a flowchart process to assist the dispatcher in collecting pertinent information for the responding emergency units, while also providing a script for the dispatcher to follow and assisting the caller in the mitigation of the emergency until emergency service units arrive. In states where such systems are not required, however, the use of such systems is typically at the discretion of the agency responsible for providing dispatching services, and, as is often the case in discretionary duties of government, there is no liability associated with not having such a system, as the public duty doctrine does not recognize an individual duty on the part of the governmental agency to any one member of the public. Thus, in the case of the sheriff who thinks the financial cost of having an EMD system is too high, a court would more than likely defer to the sheriff's judgment if someone were to sue the sheriff's department for harm claimed to have resulted from a failure to have such a system in place. In a previous module, we talked about Medicare and Medicaid funding for EMS agencies. While Medicare and Medicaid are very common funding streams for EMS agencies, there are other mechanisms by which fire departments and EMS agencies receive funding to operate. Again, medical calls involving older, disabled, or financially disadvantaged patients are often billed to Medicare or Medicaid for reimbursement. The reimbursement is defined by Medicare or Medicaid rules and commonly reimburses significantly less than full cost recovery for the EMS agency, but that is the nature of the beast, so to speak. Billing private health insurance companies for services rendered is also a routine practice that typically allows for greater cost recovery for the EMS agency than provided by Medicare or Medicaid. Those who do not have health insurance or lack adequate health insurance coverage for an ambulance transport may be billed directly by an EMS agency. Many fire departments are supported by tax dollars, as are many municipally owned EMS agencies, although recent political winds have placed burdens on that particular funding mechanism for essential services in many areas. In what appears to be an emerging trend, many fire departments and EMS agencies are finding that tax funding is not adequate to support routine operations, and they are supplementing such funding with a fee-for-service model. This practice is already common in EMS, which bills for treatment and transport services even if the agency is tax-supported. Some agencies even charge different rates for residents versus non-residents of the community served. Some fire departments are beginning to charge such fees as well, and there is even insurance available in some areas to cover costs associated with fee-for-service emergency responses. One highly contentious fee-for-service model involves billing individuals to whom the fire department or EMS agency renders aid, even if the person was not the one to call for help in the first place. Exorbitant fees are also being challenged by consumers, especially in the realm of aeromedical transports, where patients are not always able to consent to treatment or may not know the financial impacts of utilizing those services. In some areas of the country, a subscription service model is used for fire protection services, and some EMS providers, aeromedical included, are also looking at such models. There have been cases in which a subscription-based fire department refused to extinguish a fire at a house where the homeowner did not pay the subscription fee, and the court resolved the case in favor of the fire department. In what some people may consider to be a sad sign of the times, some fire departments and EMS agencies struggle to survive, especially in less populated areas served by volunteers, and routine fundraising activities are commonplace to assist the agency in purchasing necessary equipment and services. There are some areas of the country where fire departments may actually operate a private business, such as a social club, to fund its activities. Fundraising may also be performed by third-party associations or organizations to support fire department or EMS agency operations. Generally speaking, these various funding mechanisms rely on laws founded on or related to contract principles, taxation, governmental programs, or some combination of those. These funding mechanisms can vary not only from state to state, but from agency to agency. Understanding the ins and outs of how your particular agency is funded is critical for anyone involved in leadership and management positions. A basic understanding of funding mechanisms and principles is also helpful for those who do not work with billing or budgets, as a proverbial rank and file are commonly involved in completing paperwork that may have an impact on the billing and reimbursement process. Funding headaches aside, emergency service workers arguably have a very unique opportunity to provide assistance to people within their home environments. The state also has a legitimate interest in protecting people from violence, abuse, and neglect. Combine these two concepts or ideals, and the result is commonly a state law that requires firefighters and EMS personnel to report certain crimes such as child, elder, or even spousal abuse or neglect to appropriate authorities or law enforcement for further investigation. Such laws are called mandatory reporting laws, as they require the emergency services worker to report circumstances in which such abuse or neglect may be occurring. These laws typically do not provide the firefighter or EMS provider with any discretion as to whether or not the incident must be reported. As a result, these same laws routinely provide immunity from lawsuits and criminal liability so long as such reports are made in good faith. Similarly, a failure to report suspected circumstances under the auspices of a mandatory reporting law may actually give rise to civil or criminal liability. Depending on the state, there may be other mandatory reporting laws in place, such as those that require the reporting of knife or gunshot wounds to the police. The reporting of the illegal use of controlled substances, sexual assault, and other crimes may be required as well, depending on the state. If there is a suspected communicable disease outbreak, some states require that to be reported to an appropriate public health agency. These mandatory reporting laws are diverse, and their provisions can vary considerably between states. Firefighters and EMS providers should make it a point to be familiar with any mandatory reporting laws that exist within their state. Another law that is becoming commonplace across the states is some type of safe haven law that allows a parent to give an unwanted baby to healthcare workers, firefighters, police officers, or EMS providers without fear of prosecution. These laws are designed to combat those cases where a parent does not want an unborn child, leaving the baby to die somewhere unattended. These safe haven laws usually specify timeframes in which the parent can take advantage of the law. Typically, the law only allows parents to avail themselves of its provisions within a few days of the baby's birth. To encourage parents to use the law as opposed to allowing a baby to die, some safe haven laws are written to ensure the confidentiality of the parent to the greatest extent possible. If there is a safe haven law in your state, it would behoove your agency to make sure it has a process in place to accommodate the law in the event a parent ever does show up at the fire station or approaches an ambulance and hands the firefighters or EMS providers a newborn baby for whom they must now provide care. Beyond the common duties associated with fire departments and EMS agencies, states have a vested interest in ensuring preparedness for all types of emergencies. As a result, states typically have their own statewide systems for emergency management that predate the federal efforts associated with the National Incident Management System. Many states had laws that already allowed for federal preparedness grant funding to filter down to local subdivisions of government, civil liability immunity for entities or individuals working under a declaration of emergency, or the potential for emergency workers to function outside of their specific roles or scopes of practice if emergency circumstances warranted it. The 9/11 terrorist attacks in 2001 and the devastation of Hurricane Katrina in 2005 were sentinel events that really elevated the recognition of need for cohesive emergency management systems that not only function within individual states, but can interface across states and the federal government as well. In 2003, President Bush issued Homeland Security Presidential Directive 5, which outlined the executive goal to establish a single, comprehensive approach to domestic emergency incident management. Shortly thereafter, HSPD 8 further defined how federal departments and agencies were to prepare for such incidents. In 2011, President Obama released his HSPD 8, which further refined the way in which the federal National Preparedness System functioned. NIMS evolved out of the 2003 directive and is the proverbial poster child for illustrating how the federal government can interject itself into matters of state concern and purview by virtue of its spending authority. States and jurisdictions around the country follow NIMS not because there is a specific law that requires them to, but because federal preparedness assistance money and other federal grant dollars are tied to validating NIMS compliance at the state or local level. The Federal Emergency Management Agency published guidance documents to help assist agencies in achieving compliance with NIMS requirements, and again, NIMS has become the law of the land, not by official legislative action, but through the purse strings of the federal government. Another component of emergency management are trauma and public health systems. All states have some type of public health and/or trauma system in place. Progressive and well-developed systems recognize that EMS commonly serves as the first point of access for individuals to these systems and incorporates EMS into planning and other activities related to these systems. Some benefits of these systems include the recognition of infectious disease outbreaks and pandemics, coordination of resources at mass casualty incidents, and the development or communication of trauma triage guidelines for EMS providers. As far as mass casualty triage is concerned, the Federal Interagency Committee on Emergency Medical Services created a Model Uniform Code Criteria document designed to assist in improving the coordination of resources involved in EMS system mass casualty triage. As an industry-wide standard, many states have adopted the MUC for use within their own statewide trauma systems. There are also numerous laws that govern what firefighters and EMS providers would consider to be routine emergency scene operations. States have laws that define how motorists should respond to emergency vehicles. Some states make it illegal to drive over fire hose, increase criminal penalties if the victim is a protective services worker, and so on. The Federal Department of Transportation has required all workers within the right-of-way on a highway supported by federal funds to wear high-visibility safety apparel. This rule was updated in 2009 to recognize that there are many times when a firefighter cannot wear such a garment given concerns related to heat exposure or flame impingement on the fabric, which could melt and create an additional hazard for the firefighter. This high-visibility garment requirement was further updated when the Manual on Uniform Traffic Control Devices was incorporated into the DOT rule. To go a step further, OSHA has held that the use of high-visibility garments is a requirement for all persons exposed to vehicular traffic while working on a roadway, regardless of whether or not that roadway is supported by federal funds. The DOT, through the MUC-D guidelines, and the USFA, in their own publications, recognize the importance of workers' safety at the scene of vehicle accidents and delineate specific requirements that should be followed for temporary traffic control at the scene of motor vehicle accidents or other incidents on a roadway. Unfortunately, there are numerous documented cases where law enforcement and fire or EMS disagreed on how best to manage that scene, and questions as to which agency is actually in command at such a scene have been raised. There are some emergency scenes where it is clear that a fire chief or EMS chief has authority on the scene. The fire ground or the scene of an EMS incident are common routine examples. If such a scene happens to occur on a roadway, where law enforcement typically has primary authority to enforce laws and mitigate emergencies, conflicts have been known to occur. A quick internet search of "cop arrests firefighter at scene" will produce numerous hits where a firefighter was arrested over a dispute as to which agency has authority at such an incident. Firefighters and EMS providers are routinely taught to use apparatus to keep the scene safe, which commonly entails blocking several lanes of traffic as necessary. This practice is also supported by the MUC-D and USFA documents. Unfortunately, many law enforcement agencies consider it to be a greater priority to keep the flow of traffic moving, which can help reduce secondary accidents. When such disputes occur, they are indicative of a breakdown in the positive, collaborative, working relationship between different members of public safety organizations who should all have the same goal to protect and serve the public. As the laws regarding the subject are oftentimes not very clear, it is incumbent upon fire service, EMS, and law enforcement leaders to address these concerns before an incident occurs and finds its way onto social media and mainstream news outlets. As already mentioned, the 10th Amendment of the Constitution provides states with broad police powers. The term police powers does not mean the ability to arrest people or something like that, although such a function is obviously included within the umbrella of what a police power can entail. Rather, police powers in this aspect refers to the ability of the state to pass laws for the safety, health, and wellness of its citizens. In passing such laws, it is not uncommon for states to recognize special authority or actions that may be authorized for emergency service workers. Such laws allow firefighters and EMS providers to forcibly enter private property without it being a crime, to assist law enforcement, to give lawful orders to the public that must be followed, and to possibly even commandeer private property in specific circumstances. As these laws are defined by individual states, it is incumbent upon firefighters and EMS providers to be familiar with the specific police powers granted to them under the laws of their specific state. Furthermore, states have a vested interest in ensuring places of work, public assembly, commercial properties, industrial buildings, and other occupancies are free from common or special hazards that could result in a fire or other significant emergency incident. To maintain such safe environments, it is not uncommon for states to delegate authority to the local fire chief or a designee to conduct fire prevention inspections within his or her respective jurisdiction. Some states take this a step further by actually mandating such inspections be performed and may even define the frequency with which those fire prevention inspections are performed. In the event of a fire, many states require the fire chief to conduct an origin and cause investigation, and the state may also make assets available through a fire marshal's office, Department of Justice, or other state agency to assist the fire chief in fulfilling that mandate. Many states have also formally recognized Fire Prevention Week with specific legislation or executive proclamations. As far as fire inspection and prevention activities are concerned, there are private organizations that also have a significant impact on building safety and fire code compliance. One such agency is the Insurance Services Office, a New Jersey-based company that provides comprehensive data, leading-edge analytics, and other services to government and private customers. The big impact of ISO, however, is their rating of property for risk of loss by fire. ISO inspects properties to compile data that can be used to help insurance companies appropriately determine coverage premiums for the respective property. On a broader scale, ISO also rates fire departments based upon several criteria. Using their fire suppression rating schedule, communities are rated on their fire prevention and suppression capabilities given criteria that evaluates emergency communications, the fire department itself, and the community's water supply. The ISO also looks at the community's efforts to reduce losses through education, prevention, and investigation. All combined, ISO generates a rating for the community that ultimately impacts the insurance premiums paid by all property owners within the community. Needless to say, the financial pressures associated with paying insurance premiums can have some significant influence on community decision makers. Fire service leaders are encouraged to explore the ISO FSRS to see how they may be able to leverage the information to garner additional or broader support from elected officials. Investing tax dollars to improve the community's water supply, for example, may be very worthwhile for the community given the reduction in insurance premiums paid by property owners as a result. Along somewhat similar lines, progressive fire departments recognize the importance of well-drafted zoning, building, fire, and life safety codes. Such laws are typically passed at the state level, although there are home rule states where subdivisions of government and local municipalities may have some of their own codes as well. Zoning restrictions are enacted by municipalities to control growth within the community while being sensitive to the needs of residents and visitors. Competent community planners zone property to manage the distribution of residential, commercial, and industrial properties within the community to help balance the municipality's tax burden across the various types of occupancies while also considering their respective needs for various community services. In this respect, more commercial and industrial properties may mean greater tax revenues, although that may also mean more services are required to support the infrastructure required for such properties. Those communities that prefer to have less business and industry must also be willing to recognize the need for their residents to shoulder more of the community's tax burden if there is not much business and industry present to support the tax base. Zoning can be a rather complicated process, and broad categories such as residential or commercial properties are typically broken down further into subcategories that recognize differences between a large outlet store and a strip mall, or a single-family residence and a low-income multifamily apartment complex. With that being said, being aware of zoning laws within your respective community is important for any fire service or EMS leader, as zoning and community planning have significant impacts on fire and emergency services and vice versa. Building codes are drafted to address the safety and structural integrity of buildings. There can be some regional differences between building codes, and the impetus behind such codes is to ensure proper design and construction of buildings within the given state or area. Many building codes also include fire protection features within them. Rather than just delineating how much snow load a roof must be able to hold, the maximum wind speed that the building must be able to withstand, or the number of toilets and the size of the water pipes supplying the building, many codes also look at fire alarms, fire sprinklers, egress distances, and other related fire protection features. At the local community level, it can be possible to mitigate some of the costs associated with maintaining fire protection services with a fire department through building codes. If all buildings within a community have fire sprinklers, for example, there may be an argument to be made that the community does not need as many firefighters or pieces of apparatus. Limiting the height and square footage of buildings may preclude the need for an expensive piece of aerial apparatus, as another example. Fire and life safety codes are somewhat different from building codes, as building codes usually govern the initial construction or subsequent remodeling of a structure, while fire and life safety codes seek to address behaviors, practices, and features within the structures after they are built. Examples of fire and life safety codes include prohibitions on burning yard waste, the sale and use of fireworks, conditions under which extension cords can be used in the place of permanent wiring, maintenance requirements for fire extinguishers, clearance around electrical panels, storage of flammable liquids, and so on. Fire departments may be involved in the enforcement of these fire and life safety codes, depending on the jurisdiction. Additionally, being involved in the legislative process while such codes are being developed is also important for fire service leaders. Essentially, fire service professionals are very mindful of life safety advantages associated with comprehensive building, fire, and life safety codes. Unfortunately, many of these codes were developed after devastating fires that saw significant losses in both money and lives. Despite the risk to life and the potential financial impacts that follow a fire-related tragedy, property developers, businesses, and even property owners are typically driven by money and profits above all else and may see the risk posed by fire as being minor, inconsequential, or simply one of those things that will never happen to them or one of their properties. It is not unheard of for builders associations and other special interest groups to actually oppose the introduction or strengthening of building, fire, or life safety codes. Requirements to sprinkle single-family residential structures, for example, are often strongly opposed by such groups given the increased costs associated with installing such systems in light of a mistaken belief that the homeowner will never have a fire. Within the legislative process as it pertains to building fire and life safety codes, fire service professionals are often called upon to testify at legislative hearings or listening sessions. There may also be an opportunity to submit comments or feedback to legislators based upon proposed legislation, and local fire service professionals are always able to reach out to the elected officials who represent them and provide additional feedback and thoughts. While it is true that large organizations or associations have tremendous lobbying power, fire service professionals are often held in high esteem by the public and their elected officials. If both labor and management work together, support from fire chiefs as well as firefighters in a state can have tremendous influence on legislators when pondering new laws. Maintaining a united front across emergency services agencies and personnel while utilizing sound data to support their position can go a long way to influencing the legislative process in a way that is positive for the community served by those protective service agencies and personnel. A couple common differences between building codes and fire and life safety codes are the timeframes in which they are applied and the agency with oversight over their enforcement. Building codes are typically enforced actively while a structure is being designed and constructed by a local municipality's building inspector or other related agency. Once the building is constructed, however, fire and life safety codes are then routinely enforced by an appropriate agency. While that could still be the building department within a community, it is not unusual for that function to move over to the fire department. That is not to say that the building codes stop applying once the building is occupied. The building codes are still there, but so long as the structure is not modified, the building should remain in compliance with the building codes so long as it is properly maintained and does not deteriorate to the point where structural issues develop. Because building inspections are performed by governmental agencies, there are some constitutional considerations that must be addressed. Once a building is occupied, the owner, resident, or tenant has a right to privacy along with the use and enjoyment of the property free from unreasonable government intrusion. People have the right to be secure in their property and possessions. Even before the building is completed, the property owner holds specific rights that preclude trespassing on the property and, given certain circumstances, there may be reasonable privacy expectations even before a structure is completed. These constitutional rights have a direct impact on the ability of governmental entities to conduct routine fire inspections. While fire service professionals would like to claim inspection services are essential to maintain the safety, health, and well-being of the community, the right to inspect is not absolute in light of individual constitutional protections. All properties are also not created equally as far as inspection services are concerned. Commercial and industrial properties that serve the public, for example, are relatively open, and a property owner arguably has a lower expectation of privacy in those publicly accessible areas. This makes it easier to inspect such properties as well. A private residence, on the other hand, is not open to the public, and a government employee has no right to forcibly enter such a property without the existence of special circumstances. Common areas in multifamily dwellings can be inspected, but private residences are off limits. Therefore, the type of property to be inspected makes a difference as to the type of permission required to conduct a routine inspection. Initially, most inspection services are provided based upon the consent of the property owner. The inspector informs a property owner that he or she is there to conduct a routine inspection, and the property owner allows it. If such consent is withheld, however, then the inspector must receive an administrative warrant to conduct the inspection. With that being said, there are some situations in which there is a legitimate public interest in close regulation of an industry, and a warrantless administrative inspection of the property in compliance with specific requirements can be performed. These circumstances are rare, however. The case cited in the textbook, for example, dealt with an underground mining property. Typically speaking, a fire inspector seeks the consent of the property owner to conduct a fire inspection at commercial and industrial properties, as well as common areas or areas open to the public in multifamily residential structures. If such consent is withheld, however, then it becomes necessary for that inspector to obtain an administrative warrant to conduct the inspection. We talked about administrative search warrants in an earlier module and will not rehash that information here. While this is a somewhat common practice, there can be local variations based upon state and local laws. If you are involved with fire and life safety inspections and enforcement, it is important to know the laws and accepted practices in your specific area. All the zoning, building, fire, and life safety codes in the world do not mean much if there is no enforcement. Again, given the variability from jurisdiction to jurisdiction, penalties for lack of compliance with such codes can range from a simple forfeiture to criminal charges and other sanctions. In extreme situations, in order to raise the structure may even be possible. If someone is injured or killed on a property as a result of the property owner's failure to comply with building, fire, or life safety codes, additional civil liability may apply as well. So, if a property owner could be found both criminally and civilly liable for failing to comply with building, fire, and life safety codes, does that mean an inspector shares in this risk of liability if he or she fails to recognize or identify code violations while conducting an inspection? You'll be glad to hear that the short answer is no. Ultimately, it is the property owner's responsibility to ensure compliance with applicable codes. A failure on the part of an inspector to identify an issue at a property does not alleviate the original burden for the property owner to follow the law. Think of it like a traffic violation. Just because a police officer failed to pull you over for speeding does not mean you are not breaking the law. It simply means you weren't caught this time. Additionally, inspectors are human, and in the short period of time they spend conducting an inspection, it may not be possible to identify every single issue or violation, and some may even go overlooked. Despite that, the burden for the property owner still does not change. As a result, courts have consistently held that these types of inspections are governmental functions that qualify for governmental immunity. Even if such governmental immunity is waived or no longer exists given an applicable state law, courts will still typically recognize immunity under the public duty doctrine or some other theory of law. That is not to say there is never any potential liability for a negligently conducted inspection, mind you, just that such cases are very fact-specific and are impacted by the laws and previous related court decisions within the specific jurisdiction. Let's transition our discussion now from buildings and structures to something very different. While they can be easy to overlook or forget about, the duties performed by firefighters and EMS providers can have significant impacts on the natural environment. Essentially, each state has a vested interest in maintaining and protecting its natural resources, including air and water quality. The Federal Environmental Protection Agency also may come into play, with one example being the strict regulations the EPA has related to the demolition of structures that contain asbestos. In many states or areas, the intentional burning of structures is illegal unless it is related to firefighter training. Beyond asbestos and other air quality concerns associated with live burn training, water runoff in firefighting foam products may have a negative impact on the environment by contributing to what the EPA calls non-point source pollution. With this in mind, many states also require special disposal of burned structural remains. Simply burying the charred remains of a building in the ground on site or discarding the ash in a traditional landfill are practices that are becoming illegal in numerous jurisdictions. Those in the fire service recognize that live fire training is important, yet the environmental concerns and applicable regulations in place to address the byproducts of such activities are making it increasingly expensive and difficult for fire departments to perform acquired structure burns. Some states may provide exemptions from these laws for firefighter training burns, while others may allow such burns only if specific criteria are met. As always, a familiarity with the laws that apply in your specific jurisdiction are important in navigating the legal landscape related to live fire training within your geographical area. Aside from live burn training, there are other elements of firefighting and EMS that can have environmental impacts as well. As already mentioned, water runoff from extinguishment activities can be a concern. The mitigation of hazardous materials obviously has environmental concerns. The proper disposal of medical waste, including needles, is vital for EMS. Idling fire and EMS vehicles burn fuel while producing greenhouse and other harmful gases. Noise pollution can be a problem if operating in a residential area. Needless to say, the list goes on, and some of these concerns also extend to the public at large. It is not unusual for communities to limit recreational fires, and, as already mentioned, the intentional burning of a structure by a private party is not permitted in many jurisdictions. Even if there are not laws to prohibit certain activities, fire departments and EMS agencies must always be mindful of how they are perceived by the public and should take an active role in leading by example and modeling professional behavior. Caring for and being mindful of the environment is just one area in which it is important for protective service agencies to take a lead. That brings us to the end of this module. Given that this presentation was based on the last chapter within the book, many of the topics discussed were catch-all topics, which means a lot of diverse and sometimes unrelated information was discussed. To summarize, we must first once again recognize that many of the laws we discussed in this module can vary considerably from state to state. With that in mind, each state has its own requirements for becoming a firefighter or EMS provider within the state. In states that use national standards for credentialing, NREMT is a very popular nationwide credentialing agency for EMS providers. IFSAC and ProBoard are nationwide fire service equivalents. As far as the NREMT is concerned, it has adopted the 4 levels of certification as defined by NHTSA through its educational standards and recognized scopes of practice. We talked about the National Emergency Management Assistance Compact and how it allows federal EMS and medical assets to function across state borders without licensure issues. The embodiment of the EMAC is through the National Disaster Medical System, which is comprised of numerous teams that include the Disaster Medical Assistance teams, on which some EMS providers are members. Motor vehicle laws are important for emergency responders, and each state has its own laws related to operating emergency vehicles on the roadways within the state. Ethical issues and conflicts of interest laws commonly exist at the state level for governmental employees and may trickle down to local governmental employees. Individual employers, both public and private, may also have their own policies regarding ethical issues and conflicts of interest as applied to their employees. The Model Uniform Core Criteria created by the Federal Interagency Committee on Emergency Medical Services was developed to improve the coordination of resources involved in EMS mass casualty triage, and many states have adopted the MUC within their own state trauma and EMS systems. Each state has the ability to regulate for the safety, health, and well-being of its populace, which provides a mechanism for states to provide specific privileges to firefighters, EMS providers, and other emergency services personnel that are not available to average citizens. Being familiar with such laws within your state is important to understand the duties, rights, responsibilities, and expectations associated with the fire and EMS professions in your state. We explored the legalities of fire prevention activities, including the creation and application of zoning, building, fire, and life safety codes. Lastly, we wrapped up the chapter by discussing the environmental impacts of providing emergency services and some of the laws that may apply to those activities. To conclude, remember that our system of governance and laws within the United States is multi-tiered and somewhat complicated. The textbook and these presentation modules were designed to provide an overview of many of the common laws at the federal and state levels that impact fire departments, EMS agencies, and their employees or members. Separate books could probably be written about many of the topics that were discussed, so it is important to recognize that our exploration really only scratched the proverbial surface. Remember as well that while many states have similar laws, that is not always the case, and even those laws that are similar may differ in some significant ways. As you continue to explore the laws that impact you and your agency directly, be sure to identify and evaluate the laws that apply in your specific state or jurisdiction. If you have questions about a legal topic, it is also in your best interest to seek the help of a qualified and licensed attorney in your area who has subject matter expertise in the particular topic in question. With these things in mind, I hope you enjoyed these modules and learned something about the laws that impact fire and EMS agencies within the United States.